Maybe, I'm not sure.
Doesn't appear I have that option on my end.
Okay. Hang on, I'm dealing with the YouTube thing.
Yeah, once you're done with that, then we'll elevate Sergeant Castle. And if he wants to participate, he may. Okay.
I just elevated him.
Oh, thanks, Byron.
Thanks, Byron. So there's no public comment as far as I can tell. No one has raised their hand. And let's get down to new business. It is 7:09. We're moving along. We always try to finish within 2 hours. That'd be 9 p.m. New business, discussion and action. Receiving feedback from the BPD on complaints filed with 1A only.
IA, Internal
I-
Affairs.
Sorry, IA only, internal affairs only. Section 3, consider language from staff regarding the tolling question. Section 2N.
Just quickly, it looks like Sergeant Castle declined to be promoted to panelist. Just FYI.
Okay. And Sergeant Castle, if you ever wish to speak, just raise your hand, let us know. You are, of course, open to do so. Thank you for joining us today. All right, so how about 4A?
I'm sorry, what section, what page are we on, or what section?
Thought we were
So,
going to start from the beginning, but then I missed the last
Yeah,
meeting.
we're
so-
on, okay. The chair is looking at 4A of the agenda, but that 4A is receiving feedback from BPD, so that's got to get put off till next time.
yep. So a notation that'll be put off to next time.
And then 4B is,
Jump right to be
Finalize
finalizing the
the
draft.
Oh, so we're gonna start from the beginning?
so, well, how would you like to proceed? You had a bunch of questions. There were some extensive responses. We could just start from the beginning and go through.
Yeah,
Okay,
I think that makes sense.
all right. Let me pull it up.
So-
then.
So as we
Everybody
start
can
from-
chime in with their comments.
Cool. So as we start from the beginning, then we'll flag Kitty's questions. Kitty, you'll, or board member Calavita, you'll raise your questions and we'll,
Yeah, and Julian and Kit too. I mean,
yeah.
I think as we go through chronologically, everybody can raise.
Do you see that directly?
is-
Oh, yeah, no, not.
I
Okay,
know. Oh, okay.
I don't want to mess up the draft. Okay. So we all have the hard copy as well. And staff addition to section 2N.
oh, I'm sorry. I opened up the clean one. I don't want this one.
Okay.
Why not use the clean copy?
Because I had a few notes on the old one.
Okay,
And you had questions, why were certain things underlined, and
Yeah.
that's.
And
because
it
of
wouldn't exactly
you.
match a hard copy too, Kitty.
my hard copy is the clean copy.
Well, you should have gotten
Did?
both.
Yeah, I have both, yeah.
Yeah, from both. Okay, good. So it's easier for me at least to work off of the copy with the last edits. I
Okay,
can
here we
zero
go.
in and changes.
So
Okay,
thank you to Julie, who noticed that under definitions, we need to delete in these interim regs.
Okay, good.
Right. And I suggested we could just have a colon after apply.
That's a good idea.
I'm sorry, we're,
The very first sentence under definitions.
Where
Oh.
it
It
says
refers
following
to
definition.
interim regs.
yes.
Shall I just take out interim?
No,
Yeah.
take out the
Well,
whole
take out-
section.
Yeah, take out all of those words.
Okay, the entire sentence. Or the following definition shall apply, semicolon.
Yeah, you need a
And I
semicolon.
had just noted very, some nitpicky stuff, beginning with we're not consistent about capitalization. So administrative closure has a cap on closure, but if you go down lower, on 9 complaint hearing, there isn't a cap on hearing. So, just to be consistent, and it looks like there are more, there are
Yes.
fewer caps, so it makes sense just to delete the second cap unless in the regs we use the term with caps.
Okay, so
But
here.
it looks like there's more caps. So under 9, we need a cap on hearing, right?
Okay, yes.
So
I'm gonna suggest that's an excellent catch and
Yeah.
that.
I
will
was gonna
make a
say
note of-
delete-
That I'll make a
delete
note of
that.
it, but I don't think
Yeah.
you need to sit here and
Right.
watch me edit.
Yeah, that
Okay.
can be done later.
I'll just say, yes, I will look for those and
Yeah, do global
make
caps.
the appropriate changes.
Okay.
And then
So-
similarly, my third bullet was about the use of caps in the definition, and you can just look at that, Kathy. It's nothing substantive. It's just we're not consistent.
Mm-hmm.
Okay. So she's going to do a global check of those and maintain probably the caps as appropriate for both
Or
phrases.
delete, delete as appropriate.
Okay.
Right.
And then it looks like in terms of, just flag this for me too, Kitty, Julie, and Cheryl, as we're moving through. So we're in definitions now.
Yeah.
And then at 14 and 15, there were some track edits there.
Yeah.
14 was the hearing panel.
These have
That's
been
okay.
agreed upon.
Yeah. And then
Yeah.
15, informal complaint, also agreed
Yeah.
upon, right?
Right. But I
My-
proposed
Well,
I
in my,
proposed
Go
between
ahead.
13 and 14, adding formal complaint,
right,
That's right.
because informal complaint is defined and the main section, formal complaints filed with the office. So I would say we need a definition of formal complaint, and it would be a complaint alleging police misconduct filed on an ODPA complaint form and signed by the complainant.
Right. That was fine by me.
I'd like to go further and
Okay.
suggest a revision to that or an addition.
Okay.
It's,
Dr. Lee is typing it out.
yeah, I think a formal complaint, I'm going to argue that a formal complaint should incorporate a complaint filed on our complaint form by an individual, member of the public, or a board initiated complaint.
Well, that's not a formal complaint, though,
Why?
Byron. That's the reason. What?
Why isn't it?
We're not going to be,
I'm trying to simplify it. I'm not trying to complicate it, but I see
Okay.
these two processes the same. It's just how they're initiated, but they're going to follow the same path. There's going to be an investigation. There's going to be a presentation of findings and recommendations and so on. And I just think it's just easier to just,
well,
that's how we dealt with them.
I don't
um,
see the board filling out a complaint form.
No.
I'm not saying that the board has to do that.
That's why he's suggesting that we expand this definition.
Okay. So
So
how would that impact informal complaint then?
We're not talking about informal
Yeah,
complaints. We're
none.
only talking about complaints that are going to go through the investigative process and timeframes that are set forth in the charter and in these regulations. We're just talking about the same track. They're going to be different how they get started.
Right.
I just think it just makes it simpler. And also, just so you know, under the PRC, we got board initiated complaints. This isn't a new concept.
Mhm.
And we processed them the same. There was an investigation. There was a hearing. It followed the same path, except at the initiation stage. We didn't require the board to fill out a complaint. Everyone knew what that was about. And so I just think it simplifies it.
Okay. So Cheryl, you had board member Owens had her hand up.
yeah, I don't agree that a formal complaint is something that the board would initiate, primarily because I think what the board initiates is an investigation, because I don't think the board is complaining about anything. I think what
Exactly.
the board is doing is asking for an investigation to be done not a complaint to be filled out. So I don't agree that a formal complaint is something that's initiated by the board. I think what the board initiates is an investigation.
And then in that case, Board Member Owens, you would create a third definition of board initiated complaint.
No,
No, I would say the investigation is a fact find, it's right there.
So what is that process?
That's investigation.
No,
I'm
but I'd
not
like to
saying,
know.
I'm not saying the process is different, but I'm saying what initiates it is the process itself may be the same. And
Right.
Byron and I actually had this conversation. This is my vision. My vision is when a citizen comes in, they complain, they're complaining about a specific officer generally. So that's about an individual. When the board is doing it, the board, from my perspective, I don't think we're going to come in and complain about an officer because we weren't there. Most of the time, what's going to happen is citizens or someone is going to come to us and say, hey, we think there's an issue with XYZ. And at that point, I don't think we're going to complain about an officer because nothing happened that we know of at that point. So what we're doing is investigating to find out if there was something that was a violation. And kind of what I was telling Byron, the way I envision this is when a citizen comes in and complains, you're investigating the officer's action. When somebody comes to the board and says, hey, I think this is something that needs to be looked at, I think the first thing you look at is policy. Was policy violated? Yes, you have to look at individuals, officers' behavior, but you have to look at was policy violated first. And then that may lead to some other issues, but I don't think we're going to be I don't like to use the word complaint if the board initiates it, because we're not, I don't see us complaining about anything. I do see the board investigating incidents. And so I disagree with the formal complaint with the board.
What if there's an investigation and the investigation reveals some egregious act? So then,
That's my question.
yeah, so then what?
I'm not saying it may not
Lee does have her hand
lead
up.
it may not lead it. I'm not saying it may not lead to an issue with an individual officer, but I'm just saying it doesn't start with an issue with an individual officer. I'm not saying that it may end up in the same place. And like I was explaining to Byron when I talked to him, it may be the same process that the staff uses to get to whatever it is the board is interested in when they do the investigation, but I don't think that it's proper to use the term that the board is complaining because we're not focused on an officer, we're focused on an event.
Okay.
If you're focused
I
on
totally
the
agree.
event,
And
if you're focused
look at
on the
number-
event, go ahead. Sorry, Kitty.
the definition of complaint under number 7, a declaration that alleges misconduct by a sworn employee. We're not, when the board initiates an investigation, this is not an allegation of misconduct. We're asking for an investigation into something that may lead to that. Like, for example, the various instances that we've had in the past several months. You know, we're not alleging misconduct on anybody's part, but these are incidents that require further investigation. And so it seems to me, yeah, I mean, that's the reason I think we call them investigation and not a formal complaint.
A complaint and investigation are almost the same thing. It's just how it gets started. It's going to result in an investigation.
Yeah, it's going to result in an investigation, but we're not alleging misconduct from the start. We don't
Why
know.
not? Why not?
Because we don't know what happened. We don't.
So what I'm hearing is the idea for some sort of preliminary process that precedes our normal complaint process, as I've explained to you, Cheryl. And I don't know how that we can do that, given the charter. I don't know where that sounds like something new.
So I
If we
think,
can do it, my question is, what if that investigation finds something really egregious, then wouldn't there a complaint be filed then, or what happens then? I'm just not clear what, the process.
Chair, I've had my hand raised.
yeah, I was gonna, Director Lee would like to speak, please.
That's a question, the question that Board Member Leftwich had is a question that I have as well. Another question is, if we're supposed to investigate, then presumably we're interviewing officers. And if we're interviewing them, but not saying that they're not alleging misconduct, I don't, like Byron says, I don't know what this process is. And because we know what our process is now, that when we interview officers, we tell them I guess we could interview them as witness officers because we have that procedure now. If they're subject officers, then a whole bunch of rights attach to the process. And I guess if we decide that a witness officer is going to be alleged, if we think that there's possible misconduct, then we have to make them a subject officer and notify them of what the allegations are.
Right.
But it just seems, I don't know what kind of a creature we're talking about in terms of process.
Okay, so the classification issue that's tied to the process that we had, that I think we do need to be clear, otherwise it's going to be imputed. We're going to be arguing later on, once these regulations are passed, we're going to have to impute in that the board has a right to open up an investigation on the basis of there's a disparity or whatever it is. So we'll have to figure that out. Let's try to address that right now. But Board Member Owens has a question, and so does Investigator Norris after her.
So once again, I'm not a favor of the charter and the way it's written. Not that I'm saying there's anything wrong with the the responsibilities that are in there. I just don't like the way it's written. I don't think it's written very well. But with that being said, in the charter, under 14F, as it talks about the Office of the Director of Police Accountability, it says, in addition to the duties prescribed, upon receipt of a complaint by the Police Accountability Board, the Director of Police Accountability shall ensure a timely, thorough, complete, objective, and fair investigation into the complaint. So it implies that the board can initiate a complaint. I don't like that terminology, but it does say that the board will bring a complaint to the director, and the director is to do an investigation. So, I mean, we can leave the definition as the board is initiating a complaint so we can, walk hand in hand with the charter. I don't like that terminology, but in order to stay with the charter, we can use that. Like I said, I don't like using the word complaint when the board initiates it because I don't think we're complaining. But in order to get the authority to do it, that's where it's at. It's in the charter, 14F.
Okay. And I think the authority is there. That's correct. It just could be a matter of explicating it, and whether that's inclusive inside of the language that with formal complaint, the Investigator Norris just suggested, or breaking it out for specificity. So we don't have to keep having this conversation when we actually start applying these regs, where folks will ask us, where is your authority as a board to open a directed investigation, for example, which is the common term that I've experienced in the federal government and state government, where an agency has the executive discretion to open an investigation directly based upon facts it gathers, even could be newspaper clippings. We're not using that terminology here, though, but we have to decide, are we going to split out a third classification so that we don't have to argue, listen, it's in F, 4F imputed in? Or is there a way to write it in for brevity so that it can be imputed in the language itself without too much of a logical leap of having to go back to the charter again. So Investigator Norris, you had your hand up?
Yes, 14F, I think that's a matter of interpretation. I don't read that way, but I'm not here to argue against the board initiating complaint. It wasn't my main focus. It seems like what you're attempting to do is outside of what was contemplated in the charter. And because we have a complaint process. I had another point. I do want to say, Kitty, you mentioned that that's how we handled some matters in the past, but I don't know what you're referring to, but all the cases that we have, except for policy complaint, are being handled in the same manner that we've handled other complaints. So were you referring to the 2 board initiated items that were sent to staff to investigate?
So Board Member Calavita has her hand up too.
Probably.
I guess you could.
Yeah, so I am thinking that this is ideally what I think we should do. I think we should retain investigations initiated by the board. However, as Julie and others, Byron and Kathy have pointed out, that investigation might lead to an allegation of individual officer misconduct. So now I'm agreeing with Byron that under formal complaint, we need to say a complaint alleging police misconduct. Filed, I mean, I don't know if we want to say filed on an ODPA form by an individual or by the board. In other words, if an investigation leads to
A misconduct allegation.
an allegation of misconduct by the board, then that would be a formal complaint.
And then that would trigger the procedures.
That would trigger the same procedure that other formal complaints trigger. So
So
Byron, what language did you have?
Well, I had suggested the first part of that, a complaint filed on an ODPA complaint form by a member of the public or
Or by the board?
or a complaint or complaint investigation initiated by the board.
Well,
okay, should we start with something like that to try to work with it? So you're basically saying then that
sure.
this can encapsulate both an individual public member filing an allegation of misconduct against an officer, or the board possibly first starting with a policy kind of related concern driven by
No, it would-
maybe
No.
that, and then
Not a
leading
policy.
to-
No, it's not a policy
No.
complaint. An investigation that could lead to an allegation of individual officer misconduct.
Yeah, so
And-
how about a scenario where it started as a policy investigation and then it goes into the possibility of an officer related
I
allegation?
don't know why you want to insert policy there, because a policy review is a different story.
Yeah, I don't think we want to insert policy there. I'm talking about the different ways that mechanically speaking, process wise, that could bring us to this process with the board being involved in
Right.
needing to fill out a ODPA form, which I
I
think,
think it's later discussed as an investigation initiated by the board.
Yeah.
We're not talking about the board filling out a complaint form. We need to get over that. That's
Right.
that's the first clause in that definition, that an individual, a member of the public needs to complete that form. The board does not. All the
Right.
board needs to do is vote to tell staff to kick off the normal investigation. That's it. And
so
then,
for a normal investigation, let's say it goes through the process we're describing right now, where it then ends up, whichever way it started with the board, now we're looking at a particular officer alleged to have been involved in misconduct. Would somebody such as the director or the staff need to fill out an ODPA form, or they just kick immediately into an investigation, triggering the processes that provide the notification and other due process for the officer and the typically for the complainant, but in this case, it would be the board, of course.
What we do when we get a complaint from a member of the public is following a meeting with the complainant and an interview, we generate a formal notice to the police department, a notice of allegations, formally notifying the officer and the department that a complaint's been filed and an investigation is underway. For board initiated complainants, the way I see it is that following the vote of the board to initiate a complaint investigation, staff, perhaps working in conjunction with the board or not, generates that same form. There is no complaint form.
Yeah.
And
the same notice to the.
And the track is the same.
Okay.
What I'm struggling with is when I hear this notion of doing some sort of preliminary investigation before we start this formal process. That's my struggle.
I don't think anybody has said do a preliminary investigation.
That's how it comes off. That's what I'm hearing, but it could be me.
Well, okay, so here's my issue with this whole thing. I don't like saying we're complaining about an officer when we don't know if anything has happened.
Right.
So I don't like approaching it in the negative because we're just saying we hear from the public XYZ happened. I feel like the board should investigate to see if something happened. But the way this is turning into, oh, the board is going to initiate a complaint about an officer when we don't know what happened. We don't know if there should be a complaint. We don't know. So I don't like using that terminology. The only reason why I lean toward that terminology, and I'll be 100% honest, is because it tracks with what the charter says. That's the only reason why I lean toward it. Because then when the question comes up as to whether or not we have the authority to do it, it tracks exactly what it says in the charter, that the board can bring a complaint to the director. So like I said, I don't like using that term because I don't see us complaining about an officer. We weren't there. Nothing. We don't know. That's what we're trying to find out.
But once we do find out, then who? It's the same question I asked before. I agree with you, but then once the investigation is done and there is some evidence of alleged misconduct, presumably then we start the process with a complaint.
Right.
So then I think the board does need to file a complaint after an investigation reveals evidence. But then the problem with that is then we need to change complainant. We need to change the definition of complainant. I mean, we need to weigh that, weave that through the rest of the document because I don't think it's there necessarily now.
Well, I mean, if we use Byron's formal complaint definition as a complaint investigation initiated by the board, to me that takes care of all of it. Because
we could take out the word complaint because it's
but I still don't know what happens after the investigation.
Really, what happens after is the same thing that would happen if we find something was done except what if no member of the public comes forward? So we see the evidence, the board sees the evidence, but there is no one. It's essentially the board. It's essentially the board that's going to raise it as a complaint at that point.
Right. That's why I think we need to just be explicit about that.
Okay, so what can we try to fiddle with the language a bit then? I think we're all basically on the same page here. It's just like, how do we frame the language to ensure that there's an awareness that the board could potentially trigger based upon facts it gathers, an investigation of misconduct specific to an officer.
I think it's right there in the way Byron said it, a complaint and investigation by the board.
Or a complaint filed on the complaint form by a member of the public or the board after the board initiates an investigation or something like that.
But the board is not going to fill out that form.
Right.
So the board is not going to
Well, maybe it's going to have to though, ultimately, after the investigation.
I mean, that's just a formalized process. Why does the board need to fill out a form?
Who's going to be the complainant? There's all these processes.
There's no complainant.
There's no complainant.
So let me ask this though. Does that, aside from the notice form, that notification form that you provide to the police department, does the complaint form itself also have important due process types of language there for officers in terms of what's being complained of, as well as for the board's purposes in terms of its knowledge of procedures going forward in an investigation that's now being noticed to the BPD. Is there anything in that complaint form that is important that the board itself would need to have filled out or notified the officer of, or is that going to be covered, which I would assume, by the notice to the BPD itself?
It's covered by the notice. The notice informs the chief, the officer, the department that there's a formal complaint that was initiated by the board.
So that notice letter is going to cover the language substantively and procedurally of what's in the complaint form. So that's why we skip over
Yes.
that immediately. But do we need to call it a complaint investigation then? Or is there some other language? Is that clear?
What
for a
if
member of
we
the
have
public?
the hearing panel down the road? I'm just trying to think how this affects that. Can we have a hearing panel if there is no formal complaint?
Yes, and we've done it.
Yes.
We have done it for
We've done
for years under the PRC. That's what I'm telling you. Again, the PRC initiated complaints when there was no complainant available, usually in the case of a deceased individual.
And did it file also complaints on the basis of it heard some facts and it had some concerns about some type of outcome, whether that be specific to a particular officer or just in general as a practice even?
No, the PRC didn't have that authority at that time.
Right.
Only the authority to file complaints when there was no complainant.
So now we have that
Available.
enhancement. We now have that available, and we have to make sure that in the language we're capturing that. And we don't want to be too specific, but also we don't want to be too broad. And right now, what we're trying to figure out is in this formal complaint language, would that capture that kind of enhanced, whatever you want to call it, executive authority, discretionary authority to file that type of a complaint with the term complaint investigation initiated by the board? Board Member Calavita, what are your thoughts?
Well, my thoughts are if this is included in the definition of formal complaint, then section 2A1 needs to be changed because it says initiating a formal complaint. It says you have to fill out a complaint form and complaint packets must include, and then there's all this language about assuming that the formal complaint is initiated by an aggrieved party. Yeah, I
We can
mean,
go back and change that, but in terms of the definition itself, does it capture appropriately and not muddle up the fact that a member of the public, an individual member of the public can file a formal complaint on ODPA complaint on an ODPA complaint form stating that, listen, X officer has done X. And then or the board can say, we are also going to file a complaint.
yeah, where is the exact language?
So it was just added.
I don't-
Board Director
okay.
Lee, could you scroll down?
Okay.
A formal complaint, a complaint filed on the ODPA complaint form by a member of the public, and as Investigator Norris added, or a complaint investigation initiated by the board. I think that's fairly
Okay.
clean, but I want
That's
to make
fine,
sure.
as long as we keep that in mind as we move through the document.
So we got that, and maybe what are thoughts on, do we need to jump back down to section 2 now to make that correction, or will we
Let's
remember
wait till we get there. I think we should go chronologically.
chronologically? Okay, everybody okay? I still see some hands. I want to make sure if it's from before or now. Investigator Norris and then Board Member Owens. We had a little bit of freezing on the connection.
Byron, were you going to say something?
I was going to suggest if it makes it a little more palatable is to take out complaint and just have or an investigation initiated by the board.
Okay.
Well, that's not I think that the formal complaint would follow an investigation. First, we would do an investigation because we're not sure if there's an allegation of misconduct.
Let's stop there for a second, because I'm trying to resolve this in my head. When you say first we'll do an investigation, what would that look like from the?
Well, aren't you currently doing, I think that we've asked you to do investigations on the death of the individual that was released from the
Yes.
department?
What
That's
we
the type, what?
what we're doing on those, Kitty, is we're treating them like other normally filed complaints.
How are you, what are you doing?
We sent a notice of allegations to the department. We are requested evidence. We're treating it just like another complaint.
But what's the
Don't they want to
allegation?
know who the complainant is? When you treat it that way, isn't there a box for?
I mentioned earlier, when we send that form, we indicate that this was a board initiated complaint.
Well, so
Is
that's
there-
a complaint though, you're saying. A
Yes.
board, it's a complaint.
But the thing is, the complaint is defined as an allegation of misconduct, and we do not know that at this time.
We added allegations. Now, if maybe we need to refine that definition further, but we did send over an allegation or allegations on those cases.
But we weren't saying that anything was done wrong. We were just saying
Right.
we need to find out what happened. So the board did not
Right.
say we believe something inappropriate happened. The board did not say we believe policy was violated. The board didn't say anything like that. What the board said is we need to find out, get facts before we make any sort of allegation or any sort of anything, because we don't know. So I don't believe, that's why I have a hard time with this word complaint when it comes to the board, because I don't see it as, in that instance, and probably most instances when it comes to the board, I don't see us complaining, because that implies that we're saying something inappropriate happened, and we're not.
Yeah, it's
We're just trying to find out what happened.
It's very misleading. I don't like that message coming from the board to the department. Because we haven't said we haven't alleged misconduct. We're just asking for an investigation.
So I know this isn't maybe the way we did it in the past, but I don't see why it's unthinkable to find out what happened in a given, like, for example, another example is the man who died at Alta Bates Hospital,
Right.
where we don't know, for example, whether the man was still alive when the police arrived, whether he was still alive when they handcuffed him. We don't know anything about it, but we would like to learn more about it.
And my question
I
to you
don't
is,
see why it's unthinkable that the staff would find out the facts of that case.
and my
and let-
question, Kitty, is how do we do that and not have this become a personnel administrative complaint for the officer? How do
Yeah.
we do that?
So can I help this along a little bit?
No, I'm serious. This is really where we are.
Yes.
And we have to figure this out.
That's right. So I'm going to help this along right now. So what I see is going on here, there's some process naming and classification issues. So on the one hand, what you're referring to, Investigator Norris, is if it triggers the type of procedural protections, et cetera, with an allegation against a specific officer, that's an investigation, right? Is that correct? And then if you talk about the type of stuff that we're trying to decide, which is in the board meeting, something came up like the person at Alta Bates or the person behind the police department, we're not making an individualized allegation to an officer, but we do want a quote unquote, I'm just putting it in scare quotes right now, a quote unquote investigation or some type of review of the facts to determine whether or not there is a problem. And then that might then trigger an allegation. So there's a kind of a process issue here that we have to figure out. Are we going to call it something else, or does it fit into any of the boxes here? And it seems like it doesn't really fit that well into the boxes that we have currently. A lot of times.
And Chair, just quickly, I just
Yeah.
need a quick example, and maybe you can help clear this up. So in that scenario that you raised, if the board asked us to do this initial investigation to see if there's potential for filing a formal allegation.
Yeah.
who would we talk to?
Well, it depends on the facts, right? So let's say in a hypothetical, let's say
Would we
what
talk to
happened
the officer?
in the Alta base situation. Excuse you. Let's use
No,
a real
don't use,
hypothetical.
maybe we shouldn't use that one, but
Okay.
would we talk, would we talk to an officer? When the board just wants us to do an investigation, how would we approach that? And I'm sincere, I'm trying to,
Yeah, no, I'm seeing the
terms with that.
issues you're raising. Because if you speak to the officer, then that triggers the procedural protections and you're really in investigation territory.
Yeah.
Does it have
Right.
to? I don't think so. I don't think necessarily an inquiry
So
to
an
an
inquiry,
officer.
that's another way to see it too, is an inquiry that has not triggered an allegation. There's no formal allegation. There's no notification of allegation that shouldn't trigger those rights. There are process issues, of course. But if we reference it as an inquiry, a pre-investigation, there may be a better term than that, a pre-investigation inquiry to determine if there are further concerns that would be sufficient to rise to the level of an allegation. In many places that's called intake, and they just do an initial complaint review process or a kind of a directed investigation review process. And after that initial conversation, then you would trigger an investigation. So this is kind of falling into that process from what I can see. And I think we're going to have to name it. You're calling the board investigation, but is it specific enough? And it's not defined here either.
I suspect that the officer and their union would be concerned about anyone questioning their officers and who could be subject to a potential formal complaint and allegations filed against that officer.
Byron, why do we have to question the officer since we have access to all records? We could access the records within the police department in which related to that call, like officers were called to the scene at Alta Bates. We have access to those records to find out what the records show as to what happened. We're not alleging against any particular officer at this moment. You know, we want to see what the records show the facts were. Possibly even some other city office, I don't know.
It's a non-individualized, that's right. There's a non-individualized inquiry that hasn't started with individualization on a specific officer.
A collection of records to find out what happened.
And from an investigation standpoint, Investigator Norris, what type of pros and cons do you see there?
I guess it's, and I'm just thinking off the top of my head, and maybe Director Lee has something to add to this, but if we're not investigating officers and having them come over and being interviewed, that might work. I don't know, maybe that could work if you're just looking generally at
the record.
At records, assuming you'll get records in every situation, but yeah.
And not an individualized inquiry, which would amount to potentially an interview.
Which it might lead to that, which is why the reason we would put it under the possibility under formal complaint. But later there's a section on investigations initiated by the board, and that's what I visualized, that you might be collecting records to find out what happened.
Which
I'm
I think
sure
we
with
need to
regard to the man who died on the sidewalk, there will be records in the department as to what happened.
Right. So it's almost like a panel review, that's board/panel review that's non-specific to individual person, to look at the circumstances surrounding the outcome, which would be a death, for example. There's not any kind of individualization or focus or lack of a better term, targeting of an individual officer. You're reviewing the circumstances, you review the records. Then the question emerges that if you were to conduct an inquiry with a specific officer, what type of rights would that trigger? That seems to shift it into another.
Yeah, well, that would be all the rights with a formal complaint.
Right. Oh, Director Lee has her hand up.
Yes, I'm not sure that you all heard what Byron said, which was in the 2 death investigations that you initiated, we in fact did issue notices of allegation because we don't, as of yet, have any other
Process. Yeah.
process for handling something like that.
When you issued that notice, though, was there any specificity to any particular officer in that notice?
No, and that's not unusual because sometimes a member of the public will say, an officer did something to me and they don't remember the officer's name. And we, by nailing down the date of the incident, the location, we are usually able to figure out who the involved officer was. And of course, we have the complainant's name, right? So put all that information together and the department can usually identify the incident and the involved officer or officers.
Yeah, but at that point, Kathy, then once you've identified that person, it becomes an allegation against that individual.
Right, then we revise the notice of allegation to name the officer.
Okay,
Or
so-
sometimes, they'll say it was officer, so-and-so, and it's officer XY, it turns out to be officer XYZ, and then we'll amend the notice of allegations.
Okay.
I heard you say that you did send that over as an allegation. I got to tell you, I'm uncomfortable with that because I don't think we as a board were saying that we thought there was any misconduct. So I feel uncomfortable about the staff sending something over to the department saying that the board was implying that there was misconduct.
Yeah, I agree. Let me follow up with that.
So I feel uncomfortable with that, which is the reason why I feel uncomfortable with saying that the board, when they initiate an investigation or an inquiry, that we're not implying there's any misconduct.
How exactly was the notice worded, Investigator Norris and Director Lee, on the issue of the person who recently died outside of the department? What was there a specific allegation?
I think
I didn't notice.
I think the allegations included things like whether proper medical attention was given, probably something to do with releasing detainees from custody, whether that was proper. That's all I can think of off the top of my head.
And that's probably all we should discuss about those cases.
Thank you, Investigator Norris. That's helpful. Thank you for putting those guardrails up. So as a general rule, I want to say, and I understand where board member Owens is coming from. When you are doing an inquiry, you do have to have a set of questions about why you're doing the inquiry and the direction of the inquiry. That's a process issue too. In the case of what we're talking about now, the quote unquote allegations are not specific to a particular officer. However, it has to be framed with some specificity because you can't just ask somebody, we need to do a wholesale review of X practices. You need to narrowly tailor your inquiry. And so it might sound like an allegation, but it's not the same type of question as an allegation against an individual officer. So there is a little bit of difference.
But it sounds like they're using that word allegation and the word complaint. And
so maybe that we could use a different type of language, but it doesn't do the department any service either to not have that specificity. They want that to be narrowly tailored.
Right.
It wouldn't be fair otherwise.
But it's not a complaint. We haven't filed a complaint alleging misconduct.
But it's an inquiry.
Can we move back to this document? Because that other thing is kind of not, that was filed using the interim regulations and we didn't have any other method for doing it at the time. Right. But it seems to me that this formal complaint definition works okay, although I'm not sure I would use the word investigation because we're talking about complaints. We've done an investigation, we've done an inquiry, and we have a complaint that alleges misconduct. So I don't know why we don't just say, or a complaint initiated by the board.
Right, I agree.
Investigator Norris, what's your thoughts on that? Like in terms of pragmatically speaking, if we just called it a complaint initiated by the board?
I don't see what the distinction is.
I see. And then
because it's a complaint as opposed to a complaint investigation.
as opposed to an investigation, which is something we're gonna do.
Oh, I see. So you're,
In a different section.
oh, I see.
You
Yeah.
want to be aware, though, that our definition of complaint again under 7 involves misconduct by a sworn employee of the BPD.
Yes.
So we would either have to change that to
Right.
broaden it out.
No,
or we
wait,
can
but
use
at that point. at
It
the
will,
point
it
we-
will allege it.
It will allege.
At that point,
This is-
that's correct, yeah.
This is, we have an investigation and then
Yeah.
we're gonna allege misconduct.
Okay, let's go. Everyone on the same page on that?
But what I was saying is 8 then needs to be changed though, because
Not,
we
not,
then, if the board is filing a complaint, don't we then become the complainant?
No,
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 no, no,
We're still the
Oh,
board,
okay.
okay.
you have a
That's fine.
complaint without a complainant.
Okay.
yes, yes.
So
Okay,
here's where I'm struggling with this. So going back to the charter.
Yeah.
I don't think that the charter envisions an inquiry. And like I said before, the only reason why I was comfortable with a complaint investigation in that definition is because that will give us, the charter gives us the authority to initiate a complaint in 14F. So since that is where it gives us the authority to initiate a complaint, before we can issue a complaint, we have to have some sort of investigation. So that's kind of why I was kind of wrapping it all into one. But if you guys see a better way to do it, I just want to make sure that I don't want to challenge that we don't have the authority to initiate this investigation. That's all.
that's why you're adding complaint to investigation.
That's- yeah, unless you guys don't see that, you know, or you see that the charter does support this inquiry or whatever, then.
I think it does. I remember looking at, it's like right at the outset where it defines, maybe I'm not going to be able to put my hands on the charter right away, but where it says what the authority of the board is, I think it uses the word investigation right in the, oh, here it is, charter.
Okay, so let's flag that, and then if you could read that, and then Director Lee has a question, has her hand raised.
Well, actually, I have a response, which is, I read 14F differently, which is, it's the board that's receiving the complaint, not making the complaint. I don't know why this
But the board never
section is
received
written
the
this way,
complaint.
and it's.
But
like
we never
other-
get, do we get the complaint? We never get the complaint up front.
No, you never
We-
get them. So
Right, so we
I don't-
never receive a
I
complaint.
don't understand why it's written this way, unless they're speaking sort of just generally. It's like, if you file with our office, you're filing with the board.
that's what I think.
I think that's how I interpret it.
Yeah.
Well, then if that's how you interpret it, then the board doesn't have the authority per the charter to initiate a complaint. Because there's no other place in here that says you can.
Says
think
any
under
member of the
14F there-
public, right? It says any member of the public, and then in the first section, establishment and purpose, it says that the board shall provide a means for prompt, impartial, and fair investigation of complaint brought by members of the public against sworn.
Yeah, but then the definition of members of the public or the people that can file a complaint that came from the council was aggrieved parties and recipient witness. That was what was agreed to. So it couldn't just be any member of the public. It had to be somebody that was impacted either because they were the aggrieved party or they witnessed something. So it's not generalized to the members of the public. It's not that way even in the interim regulations. So
So
that's why I'm saying I don't see where, if you don't allow 14F, if you say 14F says that the board can't initiate a complaint, then I don't know where it says in this charter that the board can.
What?
I think Lieutenant Montgomery's been making that argument, but I'll let him do that when he returns. That's a
I don't
larger.
think we have to reinterpret that. I mean, it says very clearly complaints filed by the board.
Right.
And I don't think it's our job to interpret that to narrow our authority.
No, we don't want to narrow, and also obviously the legislative intent that was there was to expand the authority of the PAB from the PRC. So you wouldn't want to roll back something that already pre-existed, as Investigator Norris and Director Lee noted, as a practice under the PRC. That would not make sense in terms of the general intent.
Well, just
It's
keep in
going to be
mind,
one
though,
of those issues where we're not going to resolve it tonight. It's very complicated. And so I think it's just going to be one of the issues that we flag for the
Yeah,
city
we'll
attorney
raise it.
for the full board.
No, I think though that complaints filed by the board captures that, and the language that board member Owens was referencing 14F, I agree with that. I think it's read into that the board does have that authority to conduct investigations. And it would be very unusual if you were expanding to modern standards of police accountability boards to not have that as a tool.
Chair, modern standards aside, we have to follow our charter.
Exactly.
Yes, which I think is in there.
And I will leave this battle with Lieutenant Montgomery, because I think it's one of his core issues that he will return with us to discuss whether.
Absolutely, you'll see the revisions.
So it's been an hour, so we might want to jump ahead.
Yeah, it's
And
8
also,
o'clock.
Chair, we've since been joined by Officer Valle, and if you want to invite him to
Yes.
join as a panelist, I can promote him.
Yes, could you do so? And then Officer Valle, whenever you,
Simplify this language though, just to say a complaint filed on the ODPA complaint form by a member of the public or by the board. So we don't need to say, or a complaint initiated by.
The board's not going to fill out the form.
Filed on the-
Right.
Oh, okay. Or initiated by the board. Do we need to say the word or a complaint again? A formal complaint filed on the.
We could get rid of that comma after public, and I'll be okay.
okay. I'm in agreement with Investigator Norris, just remove the comma and then, or a complaint initiated by the board.
Yes.
And we
Okay.
took out investigation. Board member Owens, are you comfortable with that? A complaint versus complaint investigation?
I still like complaint investigation, but we've been an hour. Let's kind of try to move through the rest of this.
Sure. I'm honestly okay with either. So just flag that I don't have a problem with either. It's just a matter of nomenclature. Okay. So it has been an hour. We've had a good conversation about this. Let's move on from here.
So Julie had made a comment, I'll let Julie say, about on 16, to be consistent, we shouldn't start the definition. An informal complaint is a communication. It's just a communication.
Okay, just for grammar. A communication not on the official ODPA complaint form and remember the public that identified.
Well, I mean, it's consistent with the other definitions.
That's right. All I did was cut and paste from the other section, so that's
Okay.
why it looked like that.
That looks good to me. There's symmetry there. We've talked about this in particular quite a bit. Right now, we're just fine tuning the grammar.
And I had just some very minor stuff that, like in 12, we use the term BPD, but we don't use it anyplace else. So just,
Okay.
it looks to me like we spell it out throughout the document. So Kathy, you can just look at this. We don't need to go through all of my
Okay,
very minor stuff, but
okay, I'll
I
look
had
it
a
up.
question for the subcommittee, and that is, do you think we need to add anything else to number 13?
Well, I don't
uh,
know why we need it.
No,
Okay, all right.
I mean, I don't know why we need 13.
Oh,
No, we need 13.
Oh, okay.
yeah, I think we need it. I don't think we
Okay.
need more.
No, we don't need more.
were we writing these also for the public? Was that part of the intent?
Yes.
Okay, all right. Well, if you think it's clear enough, I don't want to dwell on this. It's not
so I
that.
think the council talked about it and, right, and agreed that recipient is the term. Or
Yeah,
we could say firsthand, I mean, but I don't know.
Okay, it's fine.
I think percipient's better, and then folks can look it up online if they need this
Yeah.
explicit definition of it. It's pretty clearly defined, right?
Okay, we can move on. Thank you.
okay, then the next thing I had, I don't know if people had anything until the next page.
Toll.
Um,
Did
yeah,
somebody-
I didn't like the definition of preponderance of the evidence. So I proposed, so in the email that I sent out, I just said it seems really awkward.
Okay.
And either we should delete the last part, but not necessarily a number of witnesses or quantity. But then I said, better yet, since the burden of proof is on the complainant and not the officer, we could just say the burden of proof on the complainant to provide evidence which outweighs or is more convincing than the evidence provided by the other party. Because the way it's written here and elsewhere, it kind of suggests that everybody has the same burden of proof, but the burden of proof in these things is on the complainant.
I don't know if that's true.
Yeah.
That's not.
Well, that's usually the way it works, certainly in any sort of lawsuit. It's not on the,
I see.
I mean, the person bringing forward the allegation, that's pretty fundamental here. We sure need to figure that out. The person bringing the allegation has the burden of proof.
It's actually, well, the way we approached it before, an individual filed a complaint, and have to use PRC as an example. And then once we accept that the complaint, that becomes an investigation of this agency. So we never saw it as being placing a burden on the complainant at that point, because it's not the complainant's investigation. Think of it that way.
Preponderance of the evidence has always meant there's more evidence on one side than the other.
So I see what you're saying, Board Member Leftwich, because although we are quasi judicial, we don't have the formality in litigation. So with the preponderance, it's totality of the circumstances. You're gathering all the facts. And then if it outweighs more on one side versus the other in terms of the allegation, then you've reached preponderance. So,
although even using the term standard of proof, I mean, that means who has to prove it. I mean, I won't beat this if everybody disagrees, but
I see what
it's
you're
kind
saying.
of strange to use a legal term like standard of proof that has a very specific meaning, is that it is on the complainant. But I hear what you're saying, Byron, that it's an investigative agency that looks at everything. So, but it's just kind of odd. It's not the way it's done usually.
Yeah, no, we pulled this off of online. I think we were reading online to make sure that it aligned with language on like legal dictionaries, etc.
Yeah, I looked at some other ones.
Isn't this the way civil suits always go?
But the burden is on the plaintiff in a civil suit. It's not on who's being sued. The burden is on the person pursuing the action.
But isn't it
their responsibility, like in a criminal case, right? It's beyond a reasonable doubt. That burden is on the prosecutors. So I hadn't thought about it until today when I was looking at this again, but.
Sure. I see what you're saying. I think if we put burdens in there, it becomes too formal, and we're not in a court. We don't have court procedures, litigation procedures with that type of formality. And then it could, if we use language like that, it could trigger a host of other questions. Whereas here you're just doing, the investigator, the staff are a neutral party. The PAB is a neutral party. They're conducting a neutral investigation of the facts. And then based upon a totality of the circumstances, applying a preponderance of the evidence, there's a determination of whether or not there's sufficiency for violation, beyond a preponderance.
We even need to use the term standard of proof because that has such a specific legal.
Yeah, I see what you're saying. What could we call it if it's not a standard? It is the standard of what we call it.
Ms. Saganor has a question. I say let's leave it alone and move on.
Yeah.
I was going to suggest we stuck this in here and I wasn't really happy about it. And I think we could probably take it out. So I'm not sure what has to be in there.
The preponderance entirely?
We refer to it elsewhere, right? Where else? I know someplace else when we talk about the hearing, maybe it's enough just to have it there. Maybe we should.
Ms. Saganor?
My comment is actually as soon as you're done with this item for the next piece.
Okay. So there's basically a suggestion now to remove it entirely. What if you're a member of the public and it's like, here's a question, like a hypothetical question. and you're thinking that you're filing a misconduct charge against an officer, and you might be confused as a criminal context. Is it a beyond a reasonable doubt? There may be some confusion there. Of course, it's not, because it's a civil issue. It's not a criminal issue, and it's in a quasi judicial versus a formal litigation or court context. So it could help in that sense. But if you guys think it's confusing and it comes up later on, and in context it makes sense later on, then we can
It
remove
does.
it.
I just
remove it
wish we
otherwise.
could find it real quickly to find out.
It's on
where-
page, it's on page 8 of my copy.
And how does
It's
it look in page
E2.
8?
Standard of proof under E2.
Oh, right.
The standard proof is there.
But it's not, I think we need to keep it defined because it's in quotes and it's not defined there.
I
Right.
agree.
I think we
should
need to
keep it.
define it.
I think it could be confusing for members of the
Yeah.
public because they confuse between criminal and civil.
Yeah.
So I would leave it there. Maybe later on we'll mess with the language, but I do recall having an extended conversation about the language, and I think some of us were pulling it off online to align it with online language.
I know, but there's lots of online sources because I did some research too. I guess
Yeah.
I'm just not sure that it's helpful to say, it's not the number of witnesses or the quantity of what? The quantity of evidence? I just think it's enough to put the period after side. More, the evidence on one side outweighs or is more convincing than the evidence on the other side.
It does say not necessarily. I don't think we're locked in.
I guess
Yeah.
I just find that doesn't add anything. It's kind of confusing.
I think it helps members of the public to understand that just because you come in with a lot of stuff.
Oh,
doesn't-
okay.
Yeah, I think that's why
I
was
think
put in
from
there.
somebody that's a layperson, I think it makes sense to them.
I would agree, as a layperson, I find it helpful.
Yeah, that's
Oh,
why I
okay.
recall it was put in there. We actually added that language in there because of that exact reason. So it's not, you can't throw a whole bunch of information or evidence and then expect that just because you have 10 witnesses versus one, that would be sufficient. So can we leave it for
Quantity,
now?
though, is it quantity of what? Number of witnesses or quantity? I guess I'm just not.
Oh, I see what you're saying. In
I think evidence.
quantity of evidence.
Quantity of evidence, yeah.
You want to add that?
Yeah.
Okay. Everyone okay with that?
Mhm.
Yep.
Okay, great. Let's move on. Good, moving on. It's 8:15. You have 45 minutes left. Ms.
There were some
Aguilar, you had it.
comments on toll.
So this is one that also my board member Leftwich commented on. And I hope this one is really simple and only takes 1 minute. And that's for toll, right? Toll, unlike most of these things, toll is used as a verb throughout the document. And the language that Leftwich suggested, I think is really good. To suspend a time period limiting certain actions.
To suspend the time period limit, could we put that in?
Suspension of, to suspend, because it's a verb, a time period limiting certain actions.
To suspend a time period limiting certain actions.
I don't know what that last part means.
Well, because it's otherwise, you have a time period that it's like a requirement, right? It's a limitation. But if it's told, it suspends that time period, which would otherwise limit certain
Or
actions.
just-
And maybe certain actions isn't the best way to put it.
Maybe
but-
just to say to suspend a time period would do it for me.
I think that would be
I'm
less.
happy with that.
Okay,
Okay.
then let's go with that. To
Okay.
suspend a time period.
Yeah, someone could impute there to suspend.
Because
the
when it's
entire
used
time
in
period.
context in the document, it gets specified about what the time period is for.
Right.
Yeah.
Okay.
Okay, cool. Next one.
Great.
Could we
One fact.
just quickly,
Oh, yeah.
Ms. Aguilar, what would you think about to suspend a time period or deadline, or is that the same?
Deadlines, yeah, that's helpful too.
Let's just
Deadline,
leave-
is that the same
let's just
thing?
leave it.
Just
Leave
leave
it.
it? Okay, let's move.
Just
Let's
leave
move.
it, just leave it.
Let's move. Let's move. We
Okay.
have consensus.
All right, what's the next one? We're at 23, we're at 24 now. We had added one, so we shifted down one from the hard
I
copy.
guess I had raised something which is the same thorny issue. It's the definition of investigation.
Okay. That's 18, the now 18, formerly 17.
The fact-finding process engaged in by the ODPA stuff. I guess I was thinking, well, no, actually I had two thoughts. One, so if the board is initiating, I guess the ODPA staff will do it, always.
Yeah.
So just to be clear that it's always through the staff. But then my other thought was, do we even need to define investigation? I mean, isn't that like kind of an obvious term?
I think
But
given our conversation and with members of the public, kind of formal versus informal complaint, I would think it helps. It
okay,
doesn't
I think it
hurt.
does. Yeah.
okay,
I say we leave it.
all right.
Come
Yeah.
on, let's get to the meat.
Great. There we go. Confidentiality.
Okay, I had something on 3 that
Okay.
I don't know, but all confidential complaint hearings, confidential investigative records. There was some discussion in a section later that talked about maybe complainants can receive redacted records. I'm wondering if we need to put anything here or if confidential handles it. If it's confidential, then that part will be redacted. So maybe we don't need anything.
From a
Yeah,
practice
I
point of
have
view,
some concerns with the idea of adding that.
Okay, never mind.
Yeah,
I'm good.
I think it's okay. I would say Investigator Norris and Director Lee, probably they have just redacted documents out when necessary, as necessary, right?
Okay, under 4, I
Whoa,
think-
whoa.
what?
Hold up.
Oh, I'm sorry.
Hold up.
Yeah. Board Member Owens has her hand up. Sorry. Whoa. Back to reins.
I hesitate to ask this question, but do we need a definition of what the member of the public is?
Okay.
Only because there's a lot of things that reference things are close to the public.
Yeah.
And there have been questions before as to whether or not the complainant or the recipient witness or whomever is a member of the public. So that's why when I saw this right here, it started making me wonder, do we need a definition of what a member of the public is? And I don't know the answer to that. I'm just throwing it out there.
isn't it anybody though? I mean, unless you want to like restrict it by residence. I mean, certainly we wouldn't be saying you have to be a resident of Berkeley.
But
No,
could
but
a
we're
member
not
of the
Well, I'm
public be
throwing
the
that out there
complainant?
because there was some challenge that the complainant was a member of the public. So that's the reason why I'm throwing that out there, because when you say you're restricting a member of the public to have certain things, and I get, yeah, you don't want the general public to get anything, but because there was some question as to whether the complainant was a member of the public. I remember this. So I'm just asking the question, should there be something in this document that explains that a member of the public is someone that's not either the recipient witness or the complainant? I'm just asking the question.
Yeah,
I
no, I
think-
get that.
We decided that, I mean, the complainant and the witnesses are members of the public. And that's the reason that they're not allowed in to question officers. And you remember we changed the part that we were going to put in interim regulations where the complainant could stay in the room when the officer was questioned. And it was considered that they had to be excluded because they're members of the public.
Okay,
And so I think in every case, we define the complainant, except when they're being questioned, of course, but the complainant is a member of the public. These closed sessions are closed to everybody, even including the officers.
Except the complainant.
Well, they're
except
not,
for the complainant. The
they're not
complainant is
closed
there.
to. That's why, and I had said that I'm concerned about that because that was the problem with that case, which held that Berkeley, that the PRC couldn't allow the public to attend, which was fine, but then the city attorney extended that to mean
Right.
that the complainant, so I don't know. I personally think it's enough to define complainant the way we have. That narrows it. And I'm not sure if we need to define member of the public.
I'm not sure it's needed because we addressed the role of the complainant throughout the document. What the complainant can do, what the complainant can do. I mean, I see board members Owens' initial concern, but I don't know if it's necessary. As
Okay,
long
that's
as-
fine.
Yeah,
We can stop. I mean, I don't want to beat it to death. It was just something that popped in my head.
Yeah.
No, thanks
So
for
if
flagging that.
everybody's good, I'm good.
no, that's good. We just don't want to go back to definitions.
Yes, right. No, that was helpful, I think, and that we do know it's throughout the rest of the document, and so the role is explicated. So on the screen there is an attempt to software update. You probably, oh, that's mine. Whoops, that was on Director Lee's. Okay, so we're at 3.
On number 4,
4, okay.
I think we need to insert electronically for any proceeding in which copies of confidential information are electronically distributed to board members.
All right.
Kathy,
So
did
add
We
you-
talked
before-
about hard
Oh.
copies and here it's electronic.
Right.
Yeah,
We had some alternate language for that and except I don't have it.
But why doesn't electronic, that works,
Well,
doesn't it?
Byron and I made this a lot simpler because what happened to this section was it was the original section was written before there was electronic records. And then, so the second part was just kind of glommed on. And then when Byron and I looked at it, he decided he could really shorten the whole thing.
okay.
But I'm sorry, I forgot about it. So I don't have it.
Do you,
So maybe can we flag this to come back?
Sure, if I agree with Kitty, I think it's pretty straightforward that it
I
should
mean-
be just adding the word electronic.
But
Because
what happens
otherwise
if I
you could
walk
put
in, what happens if I
person-
walk into their office, they hand me something, so they distribute it to me. It's not electronic, now it's not covered.
It says that the
it's
first
the
sentence is
beginning.
about the first sentence is about hard copies.
Right.
That's at an in-person proceeding. I'm not saying I'm at a proceeding.
Right.
I'm saying I
Right.
walk in their office. They hand it, well, you just happen to be here. Let me just give it to you. They hand it to
Yeah.
me. Now I'm outside of this thing. If you add
Right.
electronic or and it's not covered in the first part. That's why I just like it, leave it generic. We know if we
Not
get it.
just if hard copies of confidential information are distributed, each board member shall return. Instead of in-person proceeding, just say.
Or when hard copies, including if someone
Yeah.
walks in the
Yeah, but,
office.
yeah, but here's the thing, I'm not gonna bring it back to them and hand it back to them. And that's what that's saying. I'm not
Right.
gonna bring it back to my hand, I'll destroy it,
That-
but I'm not gonna bring
Right,
it
that's
back.
why, if we could just wait to
Leave
bring
it.
it back,
Yeah.
the revised version back to you, because I think
Okay.
we addressed all those concerns.
Okay.
okay, let's do that. You'll revise that. Thanks. Cool.
And I'm
Wait,
wondering in section 5, it talks about violations of confidentiality at a regular meeting. It seems to me that would have to be at a closed session
Right, I agree with that.
under 5.
Um,
In the
Says
middle,
Middle-
regular meeting
in
about
the middle
halfway
of
down.
5, replace regular meeting in a closed session of the board. We're not going to talk about breaches of confidentiality in an open meeting. Do you need meeting or
at a closed session.
session of the board?
Do you see that?
Yeah, I
Directly.
see that. I'm thinking about it. Okay. I guess
It
we
would,
can
in fact, be possible for someone to breach confidentiality at an open meeting, right? If,
No, that's not, we're talking about discussing it later. It's not the breach itself, it's talking about,
Right.
It's talking about
discussing.
the consequences.
you're right.
So the way I read this, and I could be 100% wrong, was that there would be a regular meeting. It wouldn't be a special meeting that would be called, but it'd just be a regular meeting. And I made the assumption at that regular meeting, there'd be a closed session. So it's
Right.
still a regular meeting. It's not a special meeting. It's just a
It's a
regular meeting
special meeting
that has.
though.
Huh?
It could
It's a
be,
closed.
it could be a special meeting, and I think
I'm not saying it wouldn't be. I'm just, well, okay,
it-
good point.
why not just say at a closed session? That covers everything.
right. Because special meeting gives us flexibility.
That's good.
Yeah,
Kathy, you had
I did.
I thought you had some concerns of whether or not this would qualify as a closed session item.
Oh, I think so.
Okay. Because the other alternative is just to say, for discussion and action at a meeting of the board, and we will know whether or not we need to do that in closed session.
I would think you would always have to, if you're going to talk about what was violation of confidentiality.
Yeah, if they violated confidentiality, it's got to be a closed session, because you got to talk about what they violated.
Exactly.
Confidential.
Okay,
Yeah,
all right,
I've thought about that. some
okay.
more.
Okay.
So I have something on the complaint form, the next section. And I know Kitty had, I think, raised the idea about deleting a comma, and then Kit said something about,
Adding a comma, yeah.
oh, okay. And then, and so for me, what I had put in email is that this uses the term, so a formal complaint alleging misconduct by one or more sworn officers must be filed on a form provided. Complaint packets must include blah, blah, blah. And so my point was, why are we suddenly talking about complaint packets? So
That's
if
a-
it's,
Excellent question.
okay, so
We
if
discussed
it's,
this, we discussed this yesterday.
Byron and I talked about this yesterday. We don't know
Oh.
how this got in
It
there.
shouldn't be there. We don't know where it came from. We have some sort of
oh, okay.
creatures in the office.
And then the
Yeah.
other thing is, I thought, I agree with Kit that this is a really
But I
long
don't,
kind
well,
of.
before you go on, Julie, can we,
Yeah.
Kathy, we had talked about getting rid of that sentence, must include information about the difference between mediation and investigation, not on the complaint form itself. So that,
I was gonna ask, what exactly is on the complaint form?
Well, there is language advising the complainant. This part is on there.
yeah,
This is there.
Yeah.
But not this part. So we want to get
I
rid
don't know
of
where
this
that came
because,
from.
because the investigator always talks about this. And our informational materials talk about it too,
But it's not the complaint.
but not the complaint itself.
Okay. And then, so one thing that's kind of confusing about using the term complaint is that we say language advising a complainant who is the subject. Wait a minute.
What?
Okay, it's the subject of commence litigation regarding is about before filing a complaint. So if they filed litigation, that is a complaint. But what's the concept? I mean, I guess I didn't realize that this was in there, that the concept is if there's already litigation pending, this just muddies the waters, or why is this in the complaint form?
Usually this has to do with criminal cases, and sometimes defense lawyers will advise their clients not to file a complaint until their case is
Okay,
over.
I was looking at this as civil litigation because it says, or has
No.
commenced, right? Has commenced litigation, that means
Oh,
they're the
right.
plaintiffs.
Right. I am only familiar with this in the criminal context. I don't know what the rationale is. I'm pretty sure this came straight from the old PRC regs. So I don't know what the rationale is on civil litigation, although it could
Maybe
be
we should
similar.
ask the city attorney's office about that,
It could be
or
similar.
something. Or if it's really criminal matters, just limit it to
Mhm.
that.
it is, I believe it is largely criminal. But Kathy, you can get rid of information? The word information? Okay.
No, I would. Oh,
Just advise the complainant.
Complaints must include language advising. That's it.
Yeah. I mean, yeah.
Okay,
Good.
Okay, I'm just thinking maybe it shouldn't be or commenced, because or has commenced, that's a reference to civil litigation.
I think I'll flag this for the city attorney.
Okay.
Okay.
Okay. And then the last thing is, there's this, the reference at the end about this language. So I was thinking we could have a separate sentence saying the form shall require the complainant to sign the following statement. Because that's what they have to sign this, right?
Yes.
So it isn't concluding with it. It's that the form shall require the complainant to sign the following statement.
What do people think? What do people think of that? I don't have a problem with that.
I think
I
that's
would
good.
I would just
think
put a
that's fair.
period after, before
Right.
filing a complaint, put a period after complaint, and then say the form shall require the complainant to sign the following statement.
Sure. Okay, I'm okay with that.
They don't have to sign it under penalty of perjury though, right?
No, I don't think we require them to do that.
No. Should just add complainant versus complaint. Require the complainant.
Oh, okay, thank you.
Okay. Cool. Okay, we're done with that. Complaint form. We're gonna have a question for the CAO. 2, who may file? Any questions or comments on this? Time check.
No,
We
I
have,
take back, I had one that I wrote, but I've taken it back, so I'm
Okay.
fine.
we have 25 minutes until we have a hard stop at 9. Investigator Norris, were you saying something?
No.
No.
Thank you.
Something on page 5, mediation B.
Okay,
Two.
anything before that?
Wait.
Okay.
Sorry.
Yeah, I thought Katie had something there.
Okay, the last sentence in 4, which is about sufficiency of complaint.
Yeah.
This section does not apply to complaints initiated by the board.
Oh, yeah, sorry, under 2A2.
That makes it sound like they don't have to be sufficient. Is that okay with everybody? I mean, that
I
applies
agree.
to
That
this.
sounds kind of weird.
It sounds a little weird to me.
Yeah,
I would just delete that sentence.
yeah.
I think I would agree with that. It makes it sound as if though the board
Can
Have
do
a
things without,
broad
without,
discretion without sufficiency. Yeah.
yeah.
I think it was,
It's kind of strange though, because what if the board
it was,
files a complaint that's totally frivolous, and
Well,
then
the
can
board-
staff recommend it be administratively closed? I mean, what if you get a wacky board that,
No, it has to be voted on by 5 board members. I think it's
Okay.
fine.
okay, but yeah, I would delete that. I agree.
Director Lee was going to say something though.
yeah, I think it was really because it's talking about what the board could do with it, that it didn't seem right for it to apply to the board. I mean, it was really more this part than the first part.
That's what I thought. It makes it sound like it applies to the whole section though.
It does sound like that.
I don't think we need it.
Okay,
I think it confuses it more than
Then clarifies, yeah.
okay.
And then in the next section, right to representation, complainants and subject officers have the right to consult with and be represented by up to, or
Right.
it's not just an attorney or other representative, they can have up to 2.
Oh, that's somewhere else.
I know, I
Right,
just
but we should be
thought it should be
consistent.
consistent here.
I agree.
Well, maybe
Well,
just say.
no, that's not true.
This is just about
because
the right to representation. I don't think we need to
Yeah.
repeat things.
if they wanted a team of 10 lawyers, they could have a team of 10 lawyers. At the hearing, they can only have 2 of them.
Oh, consult with, and, oh,
And be represented by. Okay, if everyone's fine with that.
it is kind of confusing though.
I thought it was inconsistent with being able to have 2 at the hearing.
Because I was envisioning this being the hearing too, not their general right to consult with counsel.
But when you're talking about being represented by, you're talking about at the hearing, aren't you?
That's what I thought.
We're talking about,
No.
we're talking about the interview process, the
Oh.
hearings. We're talking about the entire process.
Yeah, there's a
Okay.
lot more than just the hearing.
So
Yeah, I just thought the
Kathy, I don't-
representation.
I don't,
That's fine.
I don't know if we want to say they can bring 10 people into this process at the interview stage.
No,
Right.
thought we-
but they could consult with 10 lawyers. I think that's the point I was trying to make. And it'd be ridiculous.
Maybe we should not say
Yes.
consult with, maybe we should just say have the right to be represented and then reference to the 2.
No,
think-
because they can consult. There's such a thing as consulting with a lawyer without having them represent you, right?
Yeah.
Oh, I know, but we don't have to tell them they have that right. They have the right to do lots
I
of
would
things.
do-
I think.
So I agree with Julie. Let's leave out the consulting thing. We're just talking about who they're going to bring into the office and who's going to represent them in this process. And we want to limit that for both parties to no more than 2.
Right.
So complainants and subject officers have the right to be represented by an attorney or other representative. And
I
it's-
think we should leave it just the way it is. I don't see a problem with what it says, that they can consult with someone, they can be represented, because this isn't about the hearing, so the number of people.
Oh, but it's about in the investigation. Byron was saying, when they interview them, they don't want somebody bringing 10 attorneys.
But
Well,
this isn't-
that's fine. It says an attorney or other representative, so I'm fine with it now.
Yeah, okay.
Should we
I say leave
keep
it.
this deleted or put it back?
I say leave it.
we may have to take a vote so we can move
It's
on.
fine. It's fine. I'm fine with it the way it was.
Okay,
It was either the way it was. I mean, it doesn't really change substantively, right? Consult with
Yeah.
or be represented by.
okay.
Consultation is also something that's important. It could be the same as.
So I didn't have anything for a while. I don't know about other people.
So I had something in mediation,
Okay, what section?
B2 on
B2,
page 5.
Mm-hmm.
B2, completion.
Yeah. Yeah, so after receiving a notice from the mediator that the mediation is concluded, ODPA staff shall close the case and inform the board. And I guess one thing that I would like to see throughout all this is the board receiving more information, including not just that it's been concluded, but what the result was. So if we get the complaint, which later on it says we get the complaint.
We don't get to know.
Oh, really?
It's a completely confidential, we don't even know. Staff doesn't know.
Oh, I didn't realize that.
Well, let's
Seems
move
kind
on.
of odd, but okay. Is that,
So it's
that
a
a
little bit like
law
a
that
settlement,
limits?
like a kind of a, yeah.
I'm so what?
is that a law or is that just been practice? I mean, is that a legal limitation?
You know, it could be. I think they do they sign something, they sign a confidentiality agreement. And they
Oh.
might agree,
So-
but I don't know if it's required by law that they not say what happened, but I think that that's a, I think it's not unusual. I don't know if it's standard, but it's certainly not beyond the norm for.
Wouldn't you want to know if, assuming it's not legally limited, wouldn't you want to know if if there's some complaint and it alleges serious misconduct and goes to mediation?
But then I
Just
think what
in kind of-
happens,
Yeah,
Julia, is it shifts into kind of more of a contractual
oh, okay.
stance. And so where I work, there are versions of this where it's no longer under the enforcement authority of the federal government, then it goes into a private contractual
Okay.
process. And
Okay.
maybe that's.
I
what's
didn't
happening.
realize that the staff didn't know either, but okay.
Yeah, it's interesting. Yeah, okay.
Can we talk about C1?
Okay.
I just think that we need to put where it says it must begin immediately and be completed within 120 days of the city's discovery of an alleged misconduct. I think it should mirror what the charter says, which it says something about a person authorized to investigate and initiate an investigation. And the only reason why I'm saying that is because anybody in the city could be made aware of an allegation, and the way this is worded, that would start the clock, but the board may not know or the staff may not know about it. So I just think it should mirror what the charter says, which is somebody that has the authority to initiate an
Yeah.
investigation.
I think that's a good point.
Good idea.
Okay. How do we edit that in? What's the proposal?
I think that Kathy could probably just go back to the charter. It's in section
Mhm.
18.2 I think that's D. And just write exactly what it says, that the person authorized to initiate an investigation.
Is it easy to pull up right now so we can make it easier for
I got it.
Kathy? Or you got it? Okay, cool.
How about complaint investigations? by the discovery of the alleged misconduct by a person, right? Just,
I just think just put in, there's wording in 18.2. We just use that. It just
Yeah.
makes it easy. It just follows the charter.
Okay. Time check. We have 17 minutes until our hard stop. So at 5 minutes, I'm going to give a warning and we start to wrap it up to close it by 9.
I have a question about transmittal of complaint, because I don't remember ever seeing them. Right, shall be, complaint sent by the director shall be sent by hard copy or electronically to the chief, BPD, the board members.
I had that same question.
Yeah,
We've never seen the
I
complaint.
like the idea of it. I think we should, but I don't think,
You know,
That's-
I think this is something new under the charter, and I think we have not been complying.
Oh.
I thought we were technically complying, Kathy, that the board would get them.
They
At
would
some
get
point.
them right.
Is this
Not
contemplating?
once, not when you
That's
accept
true.
them,
Because you
we
see
get them
all
once,
the, because you see them when you get the F&Rs.
right, but we
right,
don't
but
get them.
this suggests that you do it right away. And then notice of complaint and allegations, the board isn't included about getting that.
No,
So to me, it's inconsistent, and I think we should get it. Especially if it's changed, if staff decides,
the allegations?
yeah,
What-
that's
what
where
do
it
you-
talks about that staff may add, modify, or remove allegations as they deem appropriate. So I think if we do get the original complaint, and I guess that's in the charter, we should get the complaint, and then if staff decides to modify it, we should get that too.
We actually added this in because the staff does do this. And we weren't aware, so we just put this in here when we were reviewing the regulations that we want them to tell us when they modify it.
But that's not in here that we get it. It's that it goes to the,
I don't.
sent to the complainant, the chief or internal affairs, and each subject officer. It doesn't say that the board gets it.
Why we get it when we get the FNRs that they've modified it. That's
Yeah,
what I
I guess
thought.
I'm just thinking it'd be kind of nice to be in the loop more during the process.
I think we should be in the loop on the transmittal of the complaint, the original complaint. So I agree with you 100% there. But the second part, I think if the staff modifies it, that's when we get it, when it's at the FNR stage, if they modify it, that's where we'll see it. Because they modified things and we weren't getting the fact that they modified it, and we
Right.
added this in when we were reviewing these regulations.
Right, I remember.
So I hear what you're saying, but I personally don't need to know there was a complaint transmitted and then a notice within 30 days to get another notice about that same complaint. I personally don't need all of that, but maybe the board does.
No, I don't need it either.
Okay,
Yeah, I personally don't need it. I mean, it might be helpful, like on a whatever, like as Director Lee and Investigator Norris have done on some kind of routine basis under the PRC, they provide like, here's how many have been processed, that type of thing. That's more general, systemic. But
okay.
yeah,
I do think the number 2, I think the board should be included in number 2, that with the original transmittal of the complaint, but through the process, I don't think so. So I agree with number 2, but not necessarily adding the board to number 3.
so,
Okay, that's
okay.
fine.
That sounds fine. So with number 2, Director
But
Lee,
let
would
me,
that
can I,
mean-
can I ask board members Owens and
Yeah.
Leftwich, why you think you should get it initially?
Because
Well, first, I thought Kathy said it's in the charter. But also, I just think as a board, we should be aware of what's happening. I just think it's a matter of transparency and being educated.
So do you want to, at that time, like on a routine basis, during the public meetings, oh, this is, blah, blah, blah. Or do you want it on like a quarterly basis, was a reporting out of like tracking or flow?
So I kind of personally would prefer to know as they're coming in. It doesn't sound like there's such a huge volume. right? Unless there's such a huge volume that it would be a burden, but it's just transmitting it to the board. FYI, we just got this complaint, and you say, okay, we don't,
Would that-
obviously aren't going to discuss it in a meeting, but the board. can
That'd
just
be
get
by
it
email?
via- Yeah,
How does that sound directly, Investigator Norris? Is that something
It
that?
disturbed me because,
Yeah.
we're talking about confidential information and,
Right.
you
It's
know,
more
we-
confidential information that you're getting.
it's flying around, personnel complaints. And I know Director Lee said she thought we were in violation. I don't think we were in violation. It was just a matter of when you got it. And we were trying to try to keep this process as confidential, protect it as much.
Yeah.
And we knew that you would eventually get it. And
right, but the
and the complaint-
implication of this language is that once it's accepted, you send it along, and that it's more timely. I think that's what the sense is, that we're supposed to get it. And we have to trust the board to keep confidentiality, right? Because there's lots of confidential stuff that is given to the board, so.
Sure, that's true. We are sworn. Don't we put our hand up or something? We're sworn in.
And you
Yes,
sign something.
yes, you signed something too. I understand where you're coming from, Investigator Norris, which is why I'm asking about this. I'm also asking in terms of burdens on staff. It doesn't seem like it would be because there's not a huge amount of cases that come in.
Can I make a suggestion?
Yeah.
Can we just leave this wording in there? And let's have staff continue to do what they're doing, which is let us know when there are complaints filed. Kathy tells us, XYZ, a complaint has been filed.
Right.
She does tell us that. And let's just leave it at that and not, because I don't think it matters to us what the allegations are.
I'd kind of like to know, and it does say shall be sent by hard copy or electronically, not just
Well,
reported out.
Okay, I say leave the language and then we just let
Don't
them
do
do
it.
as they've been doing. And if it becomes a problem, then we have it in the regulations that they provide us more.
So you're saying that, if it turns into something where we feel, the board members feel I'd like to know every single time and the complaint itself, then they have this here. But right now, the status quo is that we are getting updates, though not the specific complaints. And so we still have that option here.
Yeah.
And with that, I'd like to nominate Cheryl Owens for President of the United States. Moving right along.
Is that okay, Board Member Leftwich?
Yes, I personally would like to, it says they're transmitted, so I don't like the idea of saying it shall be transmitted and then we just get a statement that something was filed without getting the
So
complaint.
can I ask you, Julie?
Yeah.
What benefit or how would you use that information? So
It would just be information that I, as a board member, feel like I should be on top of.
But what,
But-
by being on top of that information, what does that allow you to do? I mean, how does
Have a
that?
sense, I guess, have a sense of what's going on in the community and what allegations are being made, but, I'm not gonna, this isn't crucial. It's just when I read it, I thought, oh, that hasn't been happening.
No, I
and I
agree.
kinda wish
I agree. I put that same comment.
We
right
were
here.
hoping you wouldn't notice.
It's certainly something.
Okay, you want the
Quite
truth?
frankly, okay, to be perfectly honest, when I wrote this, I was looking at the charter because that's clearly what the charter
Right, that's what it
says
sounds like it says. Yeah.
in 18G.
Mhm.
And then I forgot about it.
So it's written down there. What we could do if we, it is 8:52, we should start to close up. Keep this language there. Obviously, it's written in the charter. And then also when we go to the board, say, do you guys think we should get this every single time? It does say shall. That would be an added requirement. And everybody must understand that, of course, all these new documents coming in must be confidential and you have to destroy them.
And they don't have to read it. If somebody's not that interested, they don't have to look at it, right? But
Yeah, but
I just feel like,
I don't want the staff to be doing work if the board's not interested in it.
well, but if
No.
the charter says that we
This-
shall get copies,
The one
Yeah.
issue is a charter. Yeah, this is 18G.
I don't think we should ask I don't think this is something that should go to the full board. It's in the charter. It's going to stay
Right.
there.
I agree.
So that means
This is not something that's up to the discretion of the board. It has to be there.
Sure. So if it's in the charter, and
It
it's
has to
written
be there,
down.
but are you saying that they have to perform that function, Kitty? Because
No,
it's-
all I'm saying is that I don't think we should take it to the full board as a question, whether or not this wording should be
Oh,
there.
yeah, that's
Okay,
not what I
yeah,
meant.
I think
Oh,
we
It should
that's not
definitely
what
stay.
you
agree
meant.
that the wording
Okay.
should be there, but my question to you, Kitty, is, so what I'm saying is leave the wording there.
Yeah, I
They don't
understand what you're
necessarily
saying.
have to do it.
Yeah,
Where Julie is saying it's in the charter, so they do have to do it. And then,
Yeah.
then it rolled around to, maybe we should ask the board if they want the staff to do this function.
I don't
It
think
doesn't
it's,
matter if
I
they
don't
want
think
it or
it's a
not.
discretionary, I don't think we should ask because
Yeah.
the charter says it shall be done.
Okay.
I know I'm in a minority, but there is no time frame on this.
No, it
Okay.
does say at transmittal of the complaint's accepted by director. So it says when it's accepted by the director, this is what they should do with it.
Yeah.
So there
I
is a
think we
time
should-
limit on it.
Okay. So
We should be doing what it says.
I think there's not much choice if it's written into the charter.
Sorry, Byron.
It has to be transmitted. It just says
You can
shall.
still be president.
And, you know, we
Taking
have-
back your nomination of her as president?
No.
Okay, so I think we need to start to close up. It's 8:54. So we got through basically through page 5.
Huh.
That's because Julie came back.
We're going through it with
Hey, I
care.
called her yesterday. She can take a joke. I asked her, made sure she was at the meeting. So
Very good. You wanted her, yeah. And we're glad to see you, Julie, and we're glad to see you here again. And so,
Not
page
only
5
are you here, but you're at full strength too. So that's good.
Yeah.
Yes, it's quite impressive.
full strength.
Good for me.
Okay, so this is where we ended 5, and then next, do we have a when's our next meeting? Let's see on the
The 21st.
okay 21st, and let me double check the agenda here. So we've confirmed the 21st at 7 p.m. Everybody's okay with that, I'm assuming. And will Sergeant Montgomery be back then?
Lieutenant.
I'm sorry, Lieutenant Montgomery.
Yes.
Got to get that right. He will be back then. Great. And Director Lee, you'll have had the opportunity, of course, to send this draft so far so that Lieutenant Montgomery has had an opportunity to review our changes so
Sure.
far. Okay.
Is it possible we can get, I know Lieutenant Montgomery is going to bring some of his concerns. Is it possible we can get, or you can ask him to send us what those are prior to?
Sure.
That would be helpful. Yeah.
I will.
I
Thank you.
could give you the list.
You have
You
his,
know
or you just know?
I think we know what they are.
I don't know if I know what they all are.
Probably more than we realize.
That's
Yeah.
what I think.
Yeah.
Okay,
Oh, can I say one thing, which is I had 2 people ask about the section towards the end. And why was it underlined and in red? And that's because it's completely new. It was something from staff.
Okay.
But
Not
I think some things were underlined and some things
this.
weren't.
oh, okay.
This is-
Yeah,
Not
this
that's-
is-
consistent.
This is completely new.
The tolling, okay. 19 to
Okay.
22.
So,
I thought it was good.
okay, good,
Okay.
good.
So-
Then we can breeze through it.
Yeah, I thought it looked
next
good.
time.
So sounds good. Next time we'll be ready.
So Chair, could I ask one question? I know that we want to stick to a 2-hour limit.
Yeah.
But given how we're going, maybe we should, I mean, I'm not a night person, but maybe we should consider going to 9:30 next time.
What are the thoughts on this?
It's just that we're gonna need
Yes,
Yeah.
multiple
Yeah.
more.
I'm glad
meetings.
you brought this up, Kitty, because I was going to mention something tonight, and I
I
wasn't going
mean,
to mention.
I would be happy. I mean, I know that we're scheduled tonight to end, but you know,
Kitty,
So
I think we actually need more than 30, an extra 30 minutes, because we can do a whole hour on a paragraph.
Yeah.
Maybe we need another meeting.
I think we need a substantial amount of time, like a half a day. And remember, I mentioned this before. We need more time and a huge block of time, 5-6 hours. We take breaks, we come. I've done this before in other organizations, writing regulations, charter amendments. At some point, to get this thing done, I think you really need to come together for a much longer meeting.
So
Yeah.
How about just another meeting, breaking it?
Well,
maybe
we're
then-
gonna have-
No,
we're
because
gonna have
we,
several more.
for 2 hours, we've only got from page 1 to page 4.
Yeah,
You know, so also, I also think that when Lieutenant Montgomery comes to our next meeting, I think that's gonna take the 2 hours just by itself.
Oh, yeah.
So, I kind of hear what Byron's saying. I agree. I think we should have a longer period of time, and I don't think a half hour is enough. I don't know about this 4-hour thing, but I mean, I definitely think that, because otherwise we're just gonna have a bunch more meetings. So I'd rather just,
But are people available in the day? I mean, I know I am, but Mike, you're not available in the day, right?
Yeah, the day is challenging because obviously I'm working during the day.
Right.
On the weekend, there's a potential for that. So here's a couple things. I'm fine with going to 9:30, not today, because tomorrow we have a meeting too. We want to preserve everybody's energy levels. But in the future, going to 2:30 or even 10, like 3 hours, I think that's
Yeah.
okay.
Yeah.
I also get where you're going from, Investigator Norris, with regard to a 5 or 6 hour block. I think that could be challenging because I noticed that people start to flag at about 2.5 hours, and we start
Well,
to have,
I meant with breaks, obviously not 5 to 6 hours straight, but
yeah, sort of with
I
breaks.
meant, and I don't mean every meeting. I just think we need one good
Yeah.
meeting.
We might need that. Let's say that one weekend in like 3-4 weeks. Let's say after the next meeting on the 21st, if we don't have a lot of good traction after, let's say 3 hours, let's do 3 hours maximum. I think that's about the toleration of most people, and we'll have had 3 times of meeting this week. We could set a meeting on a weekend for like 4.5, 5 hours with breaks in between with the plan of we're going to finish it off. We're going to do a good job and finish off this draft with this last like 4 to 5 hour block. So that would mean one more on the 21st, and then very likely another one after that, which is a combination of like basically 2 meetings together on a weekend would work better, I think.
Just for me, it can't be that next weekend because I have plans to go to Cabo.
Yeah, that's fine. I get that. Me too.
Come hell or high water, I'm gonna get there. So that weekend of like the first week, the last weekend of April.
Yeah. That works better for me as well. What do you guys think about that?
well, it would depend on the day, but I would be willing to do that. But in
Okay.
the absence of that, I think we need to have meetings from 7 to 10 because we'll never get done.
Yeah, so on the 21st, let's plan on a 3-hour meeting. We'll be ready for that. And then after that, let's talk about a likelihood of doing like a 5-hour block.
What about the sending stuff in advance? Because I think it's helpful, but it's only helpful if everybody looks at it.
Yeah,
And then it can be kind of complicated going back and forth. So we should maybe think about that.
I thought it was helpful.
I like getting it in advance. I kind of
Yeah,
look at them as I'm going through. So I like it. Not that I didn't do it, but I had a little bit of a challenge getting the packet and printing out the document.
Right.
I still haven't gotten the packet yet. but-
Let's just tell them your packet went to Sacramento for some
Oh,
unknown reason.
Okay.
Ridiculous.
Did we
Something
lose
with the
Miss
postal
Saganor?
service. So I
I've
haven't
already
even
sent-
got mine.
Did we
I
lose Miss
finished my
Saganor?
I think we might have lost her. I think we should continue doing the pre-edits, and I generally don't offer a lot there because there's plenty of people going through it, and I think the edits are good that you're making. But for purposes of transparency, it doesn't mean that we do the pre-edits and say yes to them, and then we get to the meeting and we don't have a conversation about it. There still has to be a little bit of hashing out, and the edits are coming from different person's heads, so we've got to come to consensus on it, and it has to be heard in a public meeting. So, but it does shorten the time frame because we're jumping exactly to each of the edits that you guys have raised. So I think that's been really helpful. Is there something else you guys are recommending aside from that, though?
Chair, I wanted to ask you, we've been going page by page, and I think that's what we need to do. But our next meeting will be talking with Lieutenant Montgomery about his issues. And I'm wondering if that's a meeting. The thing is, I think in that case, we will fill the time allotted. So I don't know if it's important to go until 10 at that point, because we're
How
going to be
about
talking.
though, how about if we have Lieutenant Montgomery, how about if we get through our edits, he can send us stuff, but maybe we should just continue our process. And then the next phase is hearing his concerns, rather than interrupting the process at our next meeting with just hearing his concerns.
I personally would rather hear his concerns up front, because I'd hate for us to knock our head up against the wall about something and
Yeah,
then find out it's a huge issue for them, and then
Yeah.
kind of hear what he says and maybe want to modify what we've been beating our
Yeah,
head
okay.
against the
Yeah,
wall.
I think for transparency purposes, because he's, obviously he's an important stakeholder here as a representative of the police department, he should be there live while we're having the conversations and hash out things in a kind of dynamic way. It's
Well, he has been, but I thought this was more of a list he was gonna bring.
yeah, I
with
assume
him.
he will, and he's flagged them here and there. And some of them, may or may not require going to the city attorney. But if he brings back that quote unquote list, perhaps, I don't know if that'll be next time because he's out on leave right now. Or if we need to do it at the bigger 5-hour block or in between for efficiency, which I'm hearing from board member Calavita, that might be more efficient.
I thought he was bringing his
I-
concerns on the 21st. That's what he
Yeah.
told me
Definitely
when we
will.
were here today,
Okay.
and he would bring his on the 21st. I'm just asking if we can get a preview of it prior to it, if possible. But
Yeah.
I personally think we should focus on what his concerns are, and then finish the rest of this thing. That's kind of the way I would approach it versus us plowing through this whole thing and
Sure.
then having to go back and revisit stuff.
So we could have, as board member Calavita said, a 2-hour meeting, perhaps next time, that where we've just focused on that list. That
3.
2 or 3 hours. I think board member Calavita was thinking maybe it would take less, but it could take 3 hours. But let's say 2 to 3 hours, but focusing on the list of concerns, going through what we can or cannot address, or if it needs to go, if there's a substantive legal question that needs to go to the city attorney's office, and then have a 5-hour block on an upcoming weekend. Possibly from what I'm hearing here, we may need another meeting after the 21st before that 5-hour block. But let's see where it goes.
I say that even if he comes back on the 21st and we only spend 30 minutes and we're done with his, I still
Then
say we
right
need a
in.
3-hour meeting and we just continue on
Okay.
with what we do. If
I
he
agree.
Are
comes
you
back
okay with
with
that?
2 hours, we
Yeah.
spend
Yeah.
another hour on what we do. So the
Yes.
meeting
Sure.
on the 21st is 3 hours.
Does that make sense, board member Calavita?
Sure, that's fine.
Okay, so maybe it's 30 minutes. I don't think it's going to be, but
I don't either.
Kathy, I would just say really try to get the list in advance, because I think it would be super helpful for us to have a chance to think about it before a meeting rather than just on the spot.
Okay.
yeah, if he can bring it, he can email it to us before, that'll be super helpful. Great. Okay, we have a plan moving forward.
Okay.
And then now we have, is there any member of the public? There is someone,
Should we try to set the meeting after the 21st, the next 3-hour meeting?
okay,
Should we? That's the question.
Can we
Yes.
do it via, okay.
why don't we just,
I was
Was
just
it
gonna
the
say, can we do
3-hour?
it via
Was
email?
it the
but-
3-hour or the 5-hour?
Yeah, I thought I heard the chair say we should do another 3-hour meeting after the 21st.
it sounded like, because,
Yeah.
yeah, this is based upon an assumption that addressing the concerns that Lieutenant Montgomery will raise may take a certain amount of time next on the 21st. If we get lucky and it takes half an hour, fine, then we'll move on. But then if it does take some time, which I'm assuming, then we will need, I think, one other 3-hour meeting, 2.5, 3-hour meeting, and then that block of like 4 or 5 hours on the weekend. Does that make sense?
I think
Sure.
you should try to get it done in less time.
Okay, in like 2 meetings, the
Mhm,
21st and one more.
mhm.
So then that means the next meeting after the 21st would be the 4 to 5 hour block, which in terms of availability,
Which doesn't necessarily have to be the weekend. If you can do it on a weekday, just start earlier.
Yeah, I just, for myself, I cannot. That doesn't mean I don't have to be there, of course, but that means someone else has to chair.
Oh,
And we have a quorum issue then, I think, do we?
okay.
No, you need to be there.
No,
You should be
Yeah.
there.
Okay.
You know what?
Saturday,
I'd rather do consecutive evenings than the weekend.
Consecutive
I
evening.
think most of us relish our weekends, don't we? I mean, couldn't we have 2 nights in a row of meetings and get it done with?
Yeah, I think I agree with Kitty. I
Sure.
mean, we do it frequently that we have two nights in a row where we have.
Oh, yeah,
meetings.
sometimes 3.
Okay,
That's
so
true.
like 2 3-hour meetings in a row.
Yeah,
Okay, so that the next one is on the 21st. Then is there availability on the 28th?
Kathy, could I ask you, is our PAB meeting back on the 27th now from Tuesday?
no.
We're having it on Tuesday?
Well, it's still, there's still a possibility of change, and I wanted to talk to the board about it tomorrow.
Okay,
Okay,
Okay.
yeah, so the
And
PAB on
what
Tuesday.
we're
the
talking
26th.
about,
Yeah.
if I could just explain to the other board members, next Tuesday, the ALPR issue is coming up before the council
the 26th.
on the 26th. And so we may have a special, cancel the regular meeting on the 26th and have a special meeting on the 27th. So that really only leaves us the 28th.
Right.
We wanted to
Oh,
do 2
that's
days
not a
in a
good
row. So then we wouldn't be doing our 2 days in a row.
Yeah.
And Mondays are out for you, Cheryl?
Yeah, Mondays are really tough for me.
Yeah.
Yeah, Mondays I can't do the evenings at all.
And we're not considering Fridays?
We could do Fridays.
We could, but the 29th. Well, I guess I could do the 29th.
That's not a good Friday for me. I
Okay.
would be willing to do some Fridays, but not that one.
Okay.
Well, the first week of May is free of meetings as far as my calendar says.
There's no PAB meetings, right?
No PAB, no subcommittees
Okay.
so
The
far.
3rd and the 4th.
yeah, I get back the night of the 3rd, but I could do the 4th or the 5th.
Okay.
The 5th is Cinco de Mayo. Unless somebody's gonna deliver tacos to my house, no.
Good plan. So how about the 4th then for sure on a Wednesday?
Well, if we're only talking about a single date, we could do the 28th, couldn't we?
So how about we do this? I know we wanted to do 2 nights in a row, but why don't we do the 28th and the 4th?
Yeah,
28th, it doesn't work for me because I'm leaving early the 29th, so I want to be in a
okay.
meeting late at night on
Yeah.
the 28th.
So we have the 4th, and then what other day? The 4th at 7 p.m. again.
and the
We
3rd
talked
doesn't
about
work.
the 27th?
Let's
The
check. that.
27th, we're gonna have a PAB meeting.
Oh, right. We could have a PAB.
Oh, it's not on the 26th? Maybe I missed
Well,
that.
Kitty, are you sure you want to change it to, are you pretty sure you want to change it to the 27th? I'm just
Me?
asking.
Oh,
No, I thought we had to be at the council on the ALPRs.
You probably should,
okay.
now that I think about it. Sorry.
Sure. So the 26th will actually be the ALPR at the council meeting, which starts at what? Is that 5 to?
7. It starts at 6, and God knows when they would get to the ALPRs.
Okay.
I would hate to see us move our meeting and then they schedule a special meeting. 'Cause how many times have they done that where, it takes so long to get to whatever it is that we're waiting on, and then they end up scheduling a special meeting.
Yeah,
Is the agenda really long that day?
the councils?
Yeah.
Yeah, it's pretty long.
I know that that's something that board members should be present at.
Although the
ALPR.
ALPRs has been postponed several times, so.
So it would be bad to miss it if it was that day.
So let me throw this out there for now. This is a conversation we're gonna have with the full board, so let's not even talk about it. Because we don't know what the full
Right.
board is gonna do. So,
All right.
Good.
right?
I'm thinking,
Right.
yeah. So we'll do, let me just double check then. We're doing the
We're doing the 4th.
May 4th. Okay,
7
there's
to
a May 4th, and then Thursday the 5th. Should we do right after that?
Cinco de Mayo, Cheryl's.
Cinco de Mayo, that's right. And the 28th is out, April
Yeah.
28th.
Does May 6th work?
Friday?
Yeah.
You'd rather do a Friday night than a Saturday day, Kitty?
Oh, yeah.
Yeah, that's fine.
Yeah, I could
I
do,
mean, how early could you start, Mike, on Friday?
Let me see. I think I could potentially do a 5 o'clock.
That
It's not
helps
as
a
early
lot.
as
Yeah, that would
Yeah,
help.
I mean, if it was 5 to 8,
yeah,
I don't think I can do 5, I can do 6.
or 6 o'clock, 6 to 9.
6 to 9, can we do that?
Is that okay with the rest?
works for
Yeah,
me.
I mean, if we have to, usually we go out to dinner on Friday nights, but if we have to, we'll do it.
Okay. All right, so this Friday the 6th, 6 to 9.
So after I said that, I mean, if we have to do 5, I will try to make 5 work. I might have to duck out for a little bit, but I'll try to do 5.
How
Just
about
so,
5:30?
Will 5:30 give you more of a cushion?
let's just do 5 and I'll try to figure it out. And if not, I might have to duck out for a little bit.
Are you talking about that Friday, the 6th?
Yes.
Okay, so let's talk about 5 to 8 then. And it's okay if she has duck out, we'll catch her up.
Maybe
to
we
date.
won't need that all, you know?
Yeah, who knows?
Not.
I know us, we're gonna need it.
Would everybody besides me prefer Saturday? I mean,
Yes. No, I'm just kidding.
Prefer just because I'm fresher in the day than I am at
Oh,
I know
midnight.
Kitty would, Kathy wouldn't.
Byron will not be here in May.
But if
so-
I was, I would do a Saturday.
you don't get a say.
I don't get to say, I'm gonna share.
Let's just leave it on the Friday for now.
I say
Okay.
leave it on a Friday.
So
I say-
Wednesday and Friday.
Yeah, the 4th and the 6th. The 4th
Okay.
is from 7 to 10. The 6th is from 5 to 8.
Getting paid overtime for this?
I hope so.
Wouldn't that be nice?
That work?
Yes.
They're talking about overtime right now at council.
Really?
Yeah,
Yeah.
Okay, are we all
Okay.
all
done?
right. Great, I don't see
Okay,
any, is there any public comment? No, we're down to just the 7 of us.
I make a
We have,
that we adjourn.
I second.
Okay, no one for public comment. Great. Adjourned. Not hearing otherwise.
no one from public comment, but Officer Valle is still,
That's right. And if Officer Valle wanted to add anything, please let us know if you would like to. Otherwise, the motions have been raised for adjournment.
Agreement with adjournment.
Okay.
Oh, it was nice hearing you.
Yeah,
Okay. Good night,
Okay.
everybody.
Night.
see you
Right.
tomorrow.
Good night.
Yeah, thank